rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. Thank you.
It seems dark.
Is there a light that's not turned on? All right. Thank you. We're here today on our case number 1CA jv160038, Gila River Indian Community versus Department of Child Safety et al. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of your own time. The clock on the podium reflects the total amount of time you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, and for the appellant each time, we'd appreciate it if you would give us your name and the name of your client. We have read the briefs in this matter. We've studied the record, and we've also discussed the case in our conference. So with that, Mr. Murphy, you may proceed.
Thank you, Mom. May it please the Court. My name is Tom Murphy, and I represent the appellant, the Gila River Indian Community. Present with me today are the community's governor, Stephen Lewis, as well as members of the community's governing body, the Community Council. This is an appeal from an order of the juvenile court denying the community's motion to transfer a dependency case from state court to the community's children's court under the Indian Child Welfare Act, or ICWA, and raises issues regarding the factors relied upon by the juvenile court in denying the community's motion. The facts of this matter are straightforward.
And counsel, just so we're clear, the case and status was certainly beyond dependency. Severance of parental rights had already been entered, and it was a final order. Correct?
Your Honor, there were final determinations regarding the termination of parental rights. There was a finding of dependency. However, under Arizona's unitary, or what I would say integrated children's code, those proceedings are part of but one dependency case. There are not portions of the case that can be pieced out and transferred to tribal courts. There is one dependency case, and that's the case.
Just so we're clear, this is not a situation where the issue was foster care placement or termination of parental rights.
At this point in the proceeding, Your Honor, it was continued foster care placement, and it was not termination of parental rights.
Is Arizona law concerning dependency, severance, and adoption different from other states' procedures in that regard?
I think many states have similar proceedings, but there are different. Those proceedings are handled differently in different jurisdictions. They may have different names or different origins. For example, in New Mexico, there aren't dependency proceedings. There are abuse and neglect proceedings.
But you start off by characterizing the Arizona system as a unitary set of procedures, or a unitary procedure, and I take it that's part of your effort to explain that that the statute required transfer in this particular situation. My question is, do other states not have this quote-unquote unitary set of procedures?
Offhand, I don't know, Your Honor.
Okay.
I do know that in the legislative history of ICWA, it was recognized that not all states treat children's code or juvenile proceedings in the same manner, and I think that was one of the struggles with the statute. With regard to the facts in this matter, the petition was filed in August 2014. The community was permitted to intervene in this matter on October 31st, 2014. And as mentioned, AD was found dependent in February 2015, and in May 2015, severance proceedings were concluded. The community moved to transfer this matter under ICWA on August 18, 2015, less than a year after the matter was filed. The Department of Child Safety concurred in the motion to transfer, and neither parent made a timely or proper objection. The GAL did not respond to the motion until September 11, 2015, which was approximately 10 days after the expiration of the deadline for responding, and the foster parents did not respond until October 13, 2015, almost 2 months later. Over the objection of the community, the juvenile court set 2 days of hearings in December 2015 and January 2016. By the time the juvenile court made its decision on January 29, 2016, roughly 1/3 of the case had been devoted to the delayed transfer proceedings. When the juvenile court denied the community's motion, its basis for doing so was consideration of a change of placement for AD. This case raises 3 issues. First, the juvenile court erred in finding good cause to deny the motion to transfer. Second, the denial of the community's motion violated ICWA because the state agreed to the transfer, the objections were untimely, and the foster parents lacked standing to oppose transfer. Third, the court should not consider the arguments made regarding the limitations of Section 1911B or the constitutional attacks on ICWA because the foster parents did not cross appeal. First, there was no good cause to deny transfer in this matter. 25 U.S. Code Section 1911B states that in any state court proceeding for the foster care placement of or termination of parental rights to an Indian child not domiciled or residing within the reservation of the Indian child's tribe, the court, in the absence of good cause to the contrary, shall transfer such proceeding to the jurisdiction of the tribe, absent objection by either parent, upon the petition of either parent or the Indian custodian or the Indian child's tribe, provided that such transfer shall be subject to declination by the tribal court of such tribe.
How does this proceeding fit in with that definition? It's not. We're not dealing with a termination now, or are we? That's already been determined.
Your Honor, it's correct. The court is no longer dealing with the termination. But I sense the court is interested in the community's position with regard to the statutory construction of Section 1911B. So let me talk about that for a few minutes. Under ICWA, a termination of parental rights proceeding is, quote, any action resulting in the termination of parental rights. ICWA does not specify at what phase the action must be to permit transfer. Given the unitary or what I refer to as the integrated nature of state court proceedings, it would be difficult to interpret ICWA as requiring transfer at those specific points of the proceedings. In Arizona, jurisdiction in the juvenile court does not end until the child is 18 or is no longer dependent. Under Arizona, it's one case. The community moved to transfer one dependency case. If the court refers to the 2015 BIA guidelines in this matter, those guidelines say that a motion to transfer can be made at any time. Specifically, Section C1, the right to request a transfer occurs with each proceeding. The court provides a few examples. The right to request a transfer is available at any stage of an Indian child custody proceeding, including any period of emergency removal. There are at least 3 ambiguities in the statute here. First, the use of the phrase any action, which interestingly appears in 3 of the 4 sections in ICWA dealing with child custody proceedings. The section of the statute is called child custody proceedings. The state, or I would say the primary goal of interpreting a statute is to give effect to the drafter's intent. The appellees have relied on the doctrine of express mention implied exclusion. However, and I would quote State versus Williams in 2004, if a statute specifies under what condition it is effective, we may infer that it excludes all others. However, the aforementioned rule of statutory construction is not substantive law and serves only as an aid in determining the drafter's intent, and it should not be applied when context and public policy contradict it.
But if we, I'm sorry.
Why should we not apply that rule of construction here, where the statute does 2 things? It lays out the four kinds of proceedings, and then expressly says that 1911B, and then expressly cites only two of those proceedings in 1911B. Why should we assume that it refers to all four if it only cites two?
Your Honor, if the court goes back to the legislative history of ICWA, while the Senate version of ICWA was enacted, it included language from the House bill. And because of how late this occurred in the process, there is little reported legislative history for ICWA. But there is one key piece of legislative history, and that is the section-by-section analysis of ICWA in the House report, in its 95-1386, states as follows. Subsection B directs a state court having jurisdiction over an Indian child custody proceeding to transfer such proceedings, absent good cause to the contrary, to the appropriate tribal court upon the petition of the parents or the Indian tribe. In this particular case, the critical and the only piece of legislative history we have refers to 1911B as applying generally to child custody proceedings. In addition to that, the court should consider the impact of this proposed interpretation. After the court denied the community's motion to transfer this matter, 3 or 4 of AD's siblings were added as parties in this matter. And the matter is continuing as a dependency case. It would be inconsistent and lead to arguably an absurd result for the court to say, well, these proceedings involving this child in the dependency case are not subject to transfer because of this language, whereas the proceedings involving these 4 children who are in the same case can be transferred.
How is that absurd if they're at different points? I mean, in our case, there has already been a termination, and as I read the statute, what we're dealing with isn't necessarily included in the statute. It may be for the siblings, but not here.
And, Your Honor, that's what creates the problem, which is that as to the child involved in this appeal, AD, the parental rights have been terminated. As to the 4 siblings, they have not. And so the net effect in this case is you end up with transfer being denied as to one child, potentially granted as to the 3 other children based on the statutory interpretation that's urged by the appellees.
So you've got the legislative history. What else supports the proposition that 1911B requires the transfer absent good cause in the other 2 sorts of proceedings?
Arguably, Your Honor, I think that there are some ambiguities in how the phrase "any action" is utilized in those definitions. And I would rely, too, just on the general description of this section. For example, in Mississippi Band of Choctaw Indians versus Holyfield, as creating a presumption of transfer of child custody proceedings without making that distinction. Let me move on to the issue of whether there was good cause to deny transfer. Section 1911B recognizes concurrent jurisdiction between the tribal court and the state and a presumption in favor of tribal court jurisdiction. In this case, the trial court based its decision on factors that are not to be considered under the 2015 BIA guidelines. These guidelines expressly instruct that in determining whether good cause exists, the court may not consider whether transfer will result in a change of placement of the child. Here, all of the evidence presented in the juvenile court related exclusively to the placement of the child. Although not required to do so, the community did its best to refocus the hearing on the relevant issues by taking the extraordinary step of having one of its children court judges testify. The foster parents failed to raise in the court below what should be the primary inquiry in a transfer proceeding, which is whether the tribal court is an inappropriate forum. The legislative history of 1911B provides that the good cause exception allows state courts to deny transfer or to apply a modified version of forum nonconvenience. The doctrine is modified in the sense that there is a presumption in favor of the tribal forum. This involves considerations such as access to sources of proof, availability of process, and factors that make a case easy, expeditious, and inexpensive. In this case, there was not a single witness who testified who was not more than what I would call 15 to 20 net minutes away from the community's children's court, meaning the distance between where that witness traveled to the SEF facility and where they would have traveled to the community's children's court. And by the way, it is an opposite traffic commute. It would be difficult to find a more convenient forum based upon the proximity of the community's children's court. The record also indicated that the community's children's court was one of 2 model juvenile tribal courts in the nation, that the 2 judges have a bachelor's degree, one has a master's degree from Harvard, and they have over 35 years of experience in child welfare. They accept state court findings upon transfer and have never reversed a termination of parental rights. In short, while it was incumbent upon the objecting parties to establish that the tribal forum was not appropriate by clear and convincing evidence, they failed to present any evidence or even raise the issue below. It was raised for the first time on appeal. Second, because no timely objections were made to the community's motion to transfer by the party objecting and the foster parents, because no timely objections were made to the community's motion to transfer, and because the objecting party, the foster parents, are not identified in 1911B, the court should have summarily granted the motion to transfer. The foster parents lack standing to challenge transfer under ICWA. ICWA requires transfer unless the court finds good cause to deny transfer or either parent objects to transfer. As a child whose biological parents have had their rights terminated, it's the state of Arizona which stands in the place of the parents at this point in time, and they did not object to and concurred in the transfer of this matter to the tribal court. At the point that the tribe and the state have agreed to this transfer, as a sovereign-to-sovereign matter, the inquiry should have ended there.
But what about the fact that the juvenile court allowed the GAL to intervene? Doesn't the GAL represent the interests of the child? Shouldn't those interests be heard?
The community agrees that the GAL's interests should be heard. However, they have not participated in this appeal. They did not file a brief, and they are not appearing in this appeal.
Well, they joined a brief.
He
or she joined a brief.
After the briefing deadline was over, the GAL filed a notice of joinder in the brief of the foster parents. However, the foster parents don't have standing to raise the issues on behalf of AD, and those should not be considered by the court. On the other hand, there were issues raised by the foster parents that weren't raised by the GAL before. A simple statement of, we're not going to file a brief, but we join in the foster parents after the deadline for briefing is not sufficient in a case like this, where there are complicated and nuanced standing issues. If the GAL wanted to defend any of these positions on appeal, the GAL should have filed a brief and appeared for argument.
So the foster parents were allowed to intervene.
Yes.
Below. Why are they not a party allowed to raise issues on appeal?
I think they're a party permitted to raise issues on appeal, but however, they are not identified as a party who has the authority to veto a transfer. So I think the court may consider their views on appeal, and I think the court below consider their views on transfer. But on the other hand, I don't think that they have the authority to block a transfer, particularly when the parties identified in the statute agree.
Right. You're not suggesting this court doesn't have the authority to accept what you characterize as an untimely joinder by the GAL?
I believe the court has the authority to accept it. I don't think the court should.
Right.
I'd like to save the rest of my time for rebuttal. Sure.
Good morning, and may it please the court. Adi Dainar on behalf of pre-adoptive parents SH and JH. I want to put this case in the proper context, and I do want to address some of the questions that you asked Mr. Murphy. But this case is primarily about baby girl AD and the only family she has ever known, her pre-adoptive parents SH and JH, and their adopted son NH, who also has Native American ancestry. The decision below should be affirmed for any one of three reasons. As all of you pointed out, 1911B by its plain terms does not apply to a post-termination proceeding. The plain terms of 1911B are extremely clear that it applies to only two types of proceedings that are defined in ECWA, namely foster care placement and termination of parental rights. And this proceeding is neither of those two. If you look at the definition of termination of parental rights, you'll see that it is defined as any action that results in the termination of parental rights. And that action resulted in termination of parental rights back in May 2015, and there was no appeal from the termination of parental rights here. So that portion of the proceeding has ended. The second reason why this court should affirm the lower court's decision is because there was overwhelming evidence of good cause to deny the transfer. And the third reason is if this court wants to reverse the lower court's decision, then that really leads to serious constitutional issues. Now, Judge Winthrop, you asked about the termination of parental rights proceedings and whether there are separate proceedings, and Judge Johnson, you did as well. And the regulations, as a preview of things to come, separate out these four proceedings, just as ECWA in its definition section does. So it's plain by its terms and on its face that the termination of parental rights proceeding is not this case. So we would urge this court to simply apply the plain meaning of Section 1911B.
Is there any other provision in ICWA that would have allowed the community, had it chosen to move for transfer of jurisdiction?
Not under ICWA, Your Honor, but the community had the option of invoking the Uniform Child Custody Jurisdiction and Enforcement Act in Arizona. That's ARS Section 25-1032. And the Uniform Act in Arizona really provides for precisely this scenario, because 1911B does not reach proceedings in the post-termination stage. The Uniform Act says in those cases where ICWA does not apply, we apply the Uniform Act. And the tribe here never invoked the Uniform Act's jurisdiction transfer provision. And even if they had, that provision would have unquestionably established Arizona courts as the proper forum to decide this case, because under the Uniform Act, this court recognizes continuing and exclusive jurisdiction of the state court if a substantial relationship and substantial part of the conduct occurred in Arizona. So even under that statute, Arizona courts would obviously have jurisdiction in this case.
So Mr. Murphy told us that his reading of the legislative history, before we leave 1911, his reading of the legislative history would support the community's view that it can seek transfer at any time. And at least, I think it's in Oklahoma, the Supreme Court there kind of agrees with that view. What's your response to that?
2 points to that. One, Congress may have well considered having Section 1911B apply to all four of the proceedings, but that's not what Congress did. By its plain terms, Congress chose to apply 1911B to only foster care placement and termination of parental rights proceedings. So Congress could have chosen to put child custody proceedings in 1911B, just as it did with 1911A, which is the on-reservation children section, and they did not. So by its plain terms, 1911B does not apply in that context. The second point really goes to the mention of Holyfield that Mr. Murphy brought up. And even Holyfield recognized there is no reason to look beyond the plain terms. What Holyfield did was it looked at the word domicile in ECWA and said, by its plain terms, we don't really have to judicially invent this definition for domicile, which is readily available in common law. And the court simply applied the common law definition. And by the same token here, if the plain terms of 1911A and the definition section are plain, then there is no occasion for this court to look at the legislative history to try to glean the intent, because the intent is clear from the plain terms themselves.
And that's not, as I understand Mr. Murphy's argument, he's keen on any action as being ambiguous. Is your view that's not ambiguous?
No, it's not ambiguous because any action as it is used in the definition for termination of parental rights, it says any action resulting in. So any action as a phrase is modified by resulting in. So this court has to look at the resulting in portion of that definition, and it's plain that there is nothing else remaining in this case that would result in the termination of parental rights. That portion of the proceeding has already ended. The only thing that was required here for pre-adoptive parents to adopt was DCS consent, which DCS has given consent in this case to adopt. So when this case goes back, the adoption should occur in 1 or 2 weeks. That's the only thing that's required here. It's way beyond termination of parental rights.
Well, except that, oh no, I'm sorry, I'm thinking of something else. Go ahead.
If you have any questions regarding the plain terms, I would like to move on to the good cause standard. The characterization by Mr. Murphy of the good cause standard it needs to be modified in the following manner. Good cause, we have 3 cases. We have 4 cases that say good cause is a totality of the circumstances approach. We have another set of 4 cases that say good cause looks at forum nonconvenience plus the best interest of the child, and we have 6 cases where the courts have considered interest of the child factors in determining good cause. And the reason why that's important is because even under the traditional forum nonconvenience analysis, the unfavorable change in law that the Gila River tribe wants in this case should be given significant weight. The U.S. Supreme
What do you mean by that?
The U.S. Supreme Court, Your Honor, in Gulf Oil, in Ferentz, in Van Dusen, and Piper Aircraft, 4 cases dealing with the forum nonconvenience doctrine, said that a party that is seeking a transfer of jurisdiction cannot get a change in law as a bonus for the transfer. And here the record has been clear, especially Judge Hart's testimony in the lower court regarding what would happen if this case went to the tribal court is especially telling. She testified, and she's one of the 2 judges on the Gila River Children's Code, so her trustworthiness is really high. She testified that they don't sever parental rights in the case. They only have to look at the factual findings of the state court. They don't have to depend or adopt those legal conclusions. This is, and Gila River has really made no secret of this. The reason if transfer occurs would be a reboot of these proceedings. The termination of parental rights would be back into question. There wouldn't be really any attorneys appointed for baby girl AD. Pre-adoptive parents would only be involved in the case. They wouldn't be parties as they are in this court and as they were in the lower court because they were granted intervention. So all pieces of evidence from Judge Hart's testimony, from Ms. Enos's testimony, that's the tribal social worker, point to the fact that the only reason they're seeking transfer is a reboot of this proceeding. And if a change in substantive law is the reason for seeking transfer, then that kind of forum shopping has been struck down by the U.S. Supreme Court in 4 cases. And we implore that this court would look at those cases in analyzing the forum nonconvenience factors here. In terms of how the forum nonconvenience analysis and the best interest analysis is applied in Arizona courts, the best case to look at is the JS 8287 case, which pretty much had the same set of facts, and the court there looked at the same set of factors that the lower court did in this case. The other cases dealing with good cause really come from several Supreme Courts, Minnesota, Montana, California appellate courts, and we have fully briefed those issues as well. In terms of the timeliness objection that the Gila River tribe brought up, there are really two responses to that. As a preface, we would like to say that the scheduling order that set the schedule for filing written responses to their transfer motion is what it says, and that hasn't been part of the appeal. That wasn't included in the notice of appeal. So if you look at Lee versus Lee, if that's not included in the notice of appeal, that's not before this court. And the other and the more important reason is the fact that on August 11th, 2015, the pre-adoptive parents filed a motion to compel DCS to give consent to the adoption. If consent had been given at that point, adoption would have occurred in 1 or 2 weeks. The next day in the report and review hearing is when Greg brought up the question of jurisdiction transfer for the first time, and that's when an oral objection was made in the lower court, and that's at index of record 52 and 55. And based on that oral objection, the court then later on in September set a scheduling order, and all parties, GL and the pre-adoptive parents, filed oppositions to the jurisdiction transfer motion within the set schedule. And this court really doesn't look at scheduling orders de novo. It's really a very discretionary abuse of discretion standard, and the lower courts have their court calendars within their own authority. So it's perfectly appropriate for the court to have set a scheduling order and then for parties to have briefed the jurisdiction transfer motion at that point. With regards to standing, the standing question that Greg brought up, there are two responses. One, pre-adoptive parents have third-party standing. That's clear. If that weren't the case, then we wouldn't have Brown versus Board of Education. If that weren't the case, we wouldn't have physicians filing lawsuits on behalf of teenage pregnant moms. We wouldn't have tribes asserting interests on behalf of tribal members. If this court adopts the third-party standing position of Greg, then that's really a bizarre outcome that they are seeking as a means to get this case dismissed, and that has never been the standard under a third-party standing doctrine. As far as GIL standing is concerned, as a party and as a representative of baby girl 80, she clearly has standing to bring claims and issues before this court. The other aspect of standing and timeliness that Greg alludes to in their briefs, but it doesn't really fully explain, is the fact of the cross appeal. And really, we weren't aggrieved parties in the court below. We are fully supporting the lower court's decision. We are asking this court to affirm the lower court's decision. So if you look at Larkin, if you look at Roberts, those cases are very clear. They establish in plain terms that if these issues were raised below, which they were, in opposition to the transfer motion, then appellees can raise them again before the Court of Appeals. So by the plain application of Roberts and Larkin, the cross appeal question is not going to be an issue.
You're telling us that the pre-adoptive parents raised in the trial court, in the juvenile court here, the question of whether the transfer motion was authorized by 1911B?
That's correct, Your Honor. And that's at that's all briefed in opposition to the transfer motion, and that's also part of the written closing statements that were submitted after the 2-day trial. Unless there are no further questions. Thank you.
Thank you.
May it please the court. It's not the intent of ICWA to have some proceedings or some parts of proceedings or some participants in proceedings in state court and others in tribal court. And that's the result that the appellees urge upon this court. The construction of 1911B that they're arguing for leads to what I would call a piecemeal approach to child custody proceedings subject to ICWA. Now, as a brand new issue raised in a reply or response to an amicus brief, they say the UCCJEA is precisely what was done to answer the question here. That's not correct. The key purposes of the UCCJEA are to create consistency in interstate child custody jurisdiction and enforcement proceedings. The primary concept is to prevent competing and conflicting child custody orders between states. This application of UCCJEA would lead to inconsistent proceedings where in one dependency case you have some children or some parts of a proceeding subject to ICWA and others to UCCJEA.
No, and counsel, I don't understand why, given that that things can happen at different parts or different parts of proceedings or in different proceedings altogether, why different outcomes regarding different children are not possible. I mean, if the community had moved before the termination, we wouldn't be here today.
And that's correct, Your Honor. And I think if the court looks at the decision in or I think it was number S903, the Pima County case from this court, basically what happened is the court granted the termination of parental rights and then immediately denied the motion to transfer. And I think at the point that you start looking at those procedural points as fixed, I think that's the point at which you start getting inconsistent results or parties who might be gaming the system, for lack of a better way to put it.
Well, but counsel, I think we can all agree that the tribe certainly could have filed their motion for transfer right after the point in time where the child was taken into the care of the state. And chose not to.
And Your Honor, there may be many reasons why a tribe withholds its decision to seek transfer at any particular point of a proceeding. On the other hand, I will say this. The point at which permanency is being considered would be the point at which Indian tribes' interest in the outcome may be greater than any other prior point in the proceedings. And we're simply asking that the court uphold what is intended to be a uniform federal law in a uniform way and reverse the juvenile court. Thank you.
Thank you. Thank you, counsel. Thank you to all the lawyers for your briefing and your argument. We will take the matter under advisement and issue a decision in due course. We stand adjourned now.